I'm Vinnie Politan. The subject of my investigation is the death of Boston police officer John O'Keefe and the dramatic retrial of his girlfriend Karen Reed. After 2 months of testimony, all the evidence is in, and the jury will have to decide what was proven inside that courtroom. Here's the story. On the night of January 28, 2022, Boston police officer John O'Keefe and his girlfriend Karen Reed visited two bars in Canton, Massachusetts, C.F. McCarthy's and the Waterfall Bar and Grill. Later, they proceeded to an after-party at the home of fellow officer Brian Albert. Reed dropped O'Keefe off at Albert's residence but did not enter the house herself. The following morning, concerned by O'Keefe's absence, Karen Reed, along with Jennifer McCabe and Kerry Roberts, searched for John. They discovered O'Keefe unresponsive in the snow outside of Albert's home. Despite attempts at CPR, he was pronounced dead at the hospital. An autopsy revealed blunt force trauma and hypothermia as contributing factors in his death. Prosecutors allege that Karen Reed, intoxicated, struck John O'Keefe with her SUV and left him to die in the snow. Karen Reed maintains her innocence, asserting that John O'Keefe was attacked inside the house and that she is being framed. Both sides have presented all their evidence, and soon it will be up to the jury to decide whether or not Karen Reed is a murderer. Both sides have presented their evidence, and in the top half of the program tonight, we're going to take a look at that evidence, and we're going to analyze it, evaluate it, and then take a look at it and compare it to what this jury has to decide in the case. We're going to begin with the prosecution. Now, evidence takes different forms, just so you know what evidence is. Evidence isn't just things that are marked as exhibits. Testimony is evidence. Testimony of witnesses, facts that are elicited from the witness stand is evidence. Expert opinions are evidence as well that can help the jury interpret some of the other parts of the case. And of course, the traditional evidence, the physical stuff. The things that are marked, whether it's a document, digital evidence, or if it's actually a piece of something like a tail light in this case. So let's begin with the prosecution's case. And what we've done is we've put together what we believe are 5 of the most compelling areas of the prosecution's case, of the Commonwealth's case against Karen Reed. Let's take a look.
Did you hear or do you remember the defendant saying anything to the first responder?
Yes.
What did she say?
She told the first responder, I hit him, I hit him, I hit him.
What did she say to you?
I hit him, I hit him, I hit him.
And she answered with a series of statements that she repeated. I hit him, I hit him.
The red plastic from the debris from the clothing from 7-18.18 was found to be consistent in color, microscopic appearance, and instrumental properties with the portions that I sampled from the red plastic from the taillight.
Was the damage you saw when you looked at the car for the first time in the Sallyport area any different than the damage that appears on this Exhibit 13?
It is not. Let's have the car drive into me. But even a 2-mile-an-hour impact redirects me back and causes me to rotate and take a step.
Could you share with the jury what your opinion is to a reasonable degree of engineering certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Yes, based on the totality of the evidence, DNA, everything I've talked about, that is consistent with that happening. With a reasonable degree of scientific certainty, that is what happened.
Yes, around 12:31, 56 or 57 is the start of the health event, 36 steps.
Is that the only time that the phone moves from the point it stops at the flagpole until the next morning?
Correct. The next one is battery temperature, with the next record being made at 6 minutes after 6 a.m. when the temperature is 43 Fahrenheit.
The tech stream event ends somewhere between 12:32 and 04 and 12:32:12.
Did both these events, the last user interaction and the window captured on the reconciled data for the tech stream, happen around the same time?
Yes, they did.
The only way he could get this kind of an injury was to fall backwards, hit the back of his head, and then the resulting, energy forces going into his brain, into his base of his skull. His injuries were very substantial, and it's more probable than not that at some point he quickly became unconscious and was unable to do functional activities.
I think that gives you a good idea, a good flavor for the prosecution's case here against Karen Reed. And it brings us to the first question in our investigation. Let's take a look. Is this evidence proof beyond a reasonable doubt? Got enough pieces here to meet the burden? Here to help answer that question, John DePietro, host and creator of Road Patrol Live, and Annie Elise, host of Seriously podcast and the true crime YouTube channel 10 to Life. Great to have you both here. Thank you so much.
Thanks, Vinnie.
Okay, John, I'll start with you. And we really broke it into 5 pieces, right? We've got the I hit him, the alleged confession, the taillight fragments and the broken taillight, the blue paint expert testimony, the digital timeline that was put together, and of course, the head injury at the end. Give me your thoughts about the level of proof that we see here.
Very strong, Vinny. I mean, Hank Brennan, it's the best presentation for a prosecutor that I've ever witnessed, only because, they tell such a strong narrative. I also believe in this case that he built up such a lead that I just don't even think the defense is going to be able to come close or overcome it. But what they did so successfully, because there's no eyewitness, is they pieced together that Karen Reed and John, the ability to pair his phone with the Lexus, that was crucial. The ability to put him at the flagpole, and that eliminated that maybe he went anywhere else. Just the ability, the story they told of where this led, and then the demonstrations, whether it be the blue paint and the arm breaking the taillight, and John O'Keefe being found in a debris field full, and she had the broken taillight. But make no mistake about it, not only was Jen McCabe, Kerry Roberts, the first responders, great witnesses who all basically told the same story. John O'Keefe's niece, that was a big moment. I was in the courtroom for that. She essentially said the same thing as Jen McCabe and Kerry Roberts, and it never wavered from that. So you have strong witness testimony. She was the last one with him. And what he really did, Hank Brennan, was he drilled down. She went forward and back, and people are going to hear that. The forward and back. This wasn't an accident that she went 24 miles an hour in reverse. I hear people say that. This was an intentional act and took his life. And Vinny, I believe Hank Brennan is going to get that murder to conviction that he has set the stage for.
And and I just want to confirm something from you. What I heard from you, because you started with this, that you feel the digital timeline, the text stream plus John O'Keefe's phone,
yes,
is the strongest of the evidence, and you believe that's what kind of puts it over the top. Am I reading what you said correctly?
You are, and especially the cell phone.
Okay.
All of the jurors have a cell phone.
Okay, I've got to get to Annie on this now.
Go ahead.
John, I got to get to Annie on this. So Annie, from your perspective, looking at all this evidence, do you see it as evidence of proof beyond a reasonable doubt? Not considering what the defense is presenting, but just what this prosecution put in front of this jury, this evidence, is it enough to meet that burden?
Absolutely not. I mean, starting with the statement of I hit him, I hit him, I hit him, I understand that multiple people say they heard that. It wasn't in any report. Nobody put it in an official report. Fast forward to, I don't know, the blue paint experiment. I think anybody could right now put blue paint on their arm and position themselves in a way to move against the taillight to get that transfer looking like the same transfer that was on John's arm from those abrasions. And I understand, too, with the taillight and the debris, that is very compelling. But when you also heard from Barrows about the taillight not looking that way when he was there that afternoon before the car was taken to the Sally Port, and then it being more smashed out, that raises reasonable doubt. How did it become so smashed out? Couple that with the glass not matching on the bumper to the drinking glass. There is so much reasonable doubt here. All
right. Good news, our guests are staying with us. Coming up next, Did the defense evidence raise reasonable doubt?
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
Karen Reed is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county.
Come at me.
John O'Keefe was killed by that defendant, Karen Reed.
She's the victim of a corrupted investigation that was never about the truth.
Another big day here at the Dedham Courthouse.
Fight on. Nothing's breaking me, Matt.
You'll see it all unfold right here on Court TV.
The Karen Reed murder retrial. Live coverage weekday mornings, 8, 7 Central on Court TV.
By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision.
All right, there's Alan Jackson from his opening statement. And obviously, you're going to hear some similar things during his closing argument. But when you make an argument in court, it's got to be based upon the evidence in the case. And the defense in this case presented evidence. Some of it came out through cross-examination, but there was a lot that came out by witnesses that they actually chose to put onto the witness stand, including some experts. So I want to take some time here and take a look at what we put together, which we believe is some of the most compelling evidence from the defense. Take a look.
We accelerated that vehicle into the arm at 24 miles an hour to conduct a dynamic impact test to collect data certainly about the acceleration that the arm experienced, but then also make observations about the damage that we observed to the taillight. There's a very small crack right here in the underlying diffuser, but all of the remaining part of the diffuser in terms of this portion here and here are all intact. We did not see make any observations with respect to any fraying, holes, punctures to the material of the sleeve.
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
Do you see any defects, injury, trauma to these bones or anything associated with those bones?
I do not.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia. There's no ulcerations here. So the diagnosis of death due to hypothermia is not appropriate in his case.
You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not. What I look for is some sort of bruise, either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs. I did not observe those things.
Did you tell those law enforcement agents on August 9th, 2023, that you saw Brian Higgins and Chief Berkowitz go into the Sally Port together and alone with the SUV for a wildly long time?
That was my recollection at the time.
So you did say that?
At the time, that is what I recollected.
Okay, he told you two things. Commissioner Cox told you, number one, the Boston Police Department supports you, and Officer Deaver, do the right thing.
So he said my name correctly. He said Dever, and
that's my mistake. Let's see. You want me to repeat the question so I get
So,
right?
Mr. Jackson, let's go ahead and answer, please.
Yes, and he said nothing with the intent of guiding me one way or the other.
What his intent was, madam. I asked you what he said to you. What were his words to you?
That he supports me.
Were you able to come to any conclusions or opinions about the source and nature of the injuries that you see depicted on that exhibit?
Yes.
And what is your opinion and conclusion concerning those injuries?
Those wounds were inflicted as the result of a dog attack. I believe that this hole was made by a canine tooth, and with the tooth going into the shirt, reaching the skin, and then coming out of the shirt, pulling out some fabric with it.
I'm sure the owner of the house will receive some.
And could you read Mr. Proctor's 2 responses?
Nope. A homeowner is a Boston cop too.
Mr. Proctor says, from all accounts, he didn't do a thing wrong. She's a whack job. And then uses the C word to describe. Oh, she's skating? 0 chance she skated. She's effed. She's
Yes.
Is that what he said?
It is.
Do you see Michael Proctor in this video?
I believe that's him, yes.
Which area is Michael Proctor walking to? The left rear or the right rear in this footage?
It appears if that's him, he's walking to the right rear of the vehicle.
So the defense presented evidence is a little bit different, their focus, than the first trial. But all this brings us to the next question in our investigation. Did this evidence raise reasonable doubt? That's the goal of every defense team, is to raise a reasonable doubt. Sometimes they don't present evidence. They did in this case. Helping us with our investigation, John DePietro, along with Annie Elise. All right, Annie, looking at all that evidence, we put together 5 examples: the accident reconstruction, the medical examiners, Officer Dever's testimony, the dog bite evidence, former Trooper Michael Proctor. Were they successful through their own evidence, raising reasonable doubt here?
Absolutely. Starting with the ARCA and the reconstructionist, that illustrated that the taillight wasn't as damaged as Karen Reed's was. It also showed just the impact is so different. And I think going into the Sally Port and Michael Proctor being in there, and when Dever says they went in there for a wildly long amount of time, that certainly creates reasonable doubt as to what were they doing in there? Why is she now having, according to her, a false memory of that? And then with the dog bites as well, we've already heard too how the dog has been rehomed, how the dog wasn't there that morning. There's so much reasonable doubt. And I think the absolute biggest thing with all of this is what the medical examiner said. According to the Commonwealth's own medical examiner, she specifically performed the autopsy and examined the lower extremities of John O'Keefe's body, and she found no evidence of any impact injuries that are consistent with being hit by a vehicle. So I think the first questions that the jurors are going to have to ask themselves when they get in the deliberation room is, was there a collision? Was John O'Keefe hit by a car? And if the answer is no, then I think that's that right there. Murder, too, I certainly think there's a lot of reasonable doubt. There's no motive. This was not intentional if it did happen. There's voicemails of her asking where he is, concerned, upset that he hasn't come home. I think all of that is going to definitely be in the jury's mind when they're deliberating.
John DePietro, same question. Did this evidence raise reasonable doubt, the evidence presented by the defense?
It did not, Vinnie. And the defense this time, they ran into a prosecutor who happens to be a criminal defense attorney, and Hank Brennan just put on a show for the jury. He tore apart the defense witnesses, and the defense, look at what we're parsing words of the car didn't, she didn't hit him. It wasn't a collision. That's certainly not what Welcher showed. By the way, there is video also of Karen where she says, I probably said I hit him. Hank Brennan managed this case. He presented it in a very easy to understand way. And Vinnie, what they could not overcome, and none of this overcomes reasonable doubt, but the biggest star, the witness of the trial, was the defendant herself, Karen Reed, and all those Karen clips that the jury's familiar with. They're going to see them again. There's not reasonable doubt. In any case, maybe there's some doubt. But she went forward intentionally. She backed up intentionally. That's murder too. They may parse, this, or did she say the question mark, or did I clip him? Did I hit him? Did I didn't hit him. But the bottom line, the defense, they were up against it with those clips. And it's very rare, I'm sure, that they run into a prosecutor who's as skilled at cross-examination as Hank Brennan.
So, Annie, as you look at the defense case, from your perspective, is it Is it about the physical injuries of John O'Keefe that you find most compelling, the lack of the injuries?
I think that's probably going to be the most compelling piece when they're looking at it just scientifically and very matter-of-factly. But then you start layering in everything else, such as the dog bites, the text messages between Brian Higgins and Karen Reed, the deleted browser history and call history, more butt dials that I have ever heard of in my entire life. And you piece all of that together when they're reviewing the evidence. And that's what leads me to believe that they will see that there is a lot of reasonable doubt here.
And John, before we run out of time here, about 30 seconds or so, this is the second trial. So there was doubt in the first trial, right? At least 3 jurors had a doubt that there was even a collision. Right. How did it change this time around from your perspective if you don't think that doubt's there?
As far as the clips of the defendant, the cell phone, John's cell phone, and put it all outside the house. That was always a problem for the defense. The way they mapped his phone with the Lexus, that was very, very effective. And just Brennan's, the way he told the story and the way that they made it definitive that John O'Keefe stepped out of that car and 10 seconds later, his phone never moved again. I think they built up an early lead. This was a tough case for Alan Jackson.
Well, I think it's a tough case for both sides. It's going to be the toughest case for the jury, right? They've got to figure it all out. Annie Elise, seriously, the podcast is awesome. Thank you so much, John DePietro, Road Patrol Live. We'll see you again soon.
Thanks,
Up next, will this case provide a blueprint for future high-profile defendants? I'm Vinnie Politan. We continue our investigation of the death of Boston police officer John O'Keefe. Over the course of 2 months, the jury heard dozens of witnesses and saw dozens of exhibits. Now 12 men and women in the jury will have to figure out what it all means. Here's the story. The death of Boston police officer John O'Keefe on January 29, 2022, in the snow outside of 34 Fairview Road in Canton, Massachusetts, sparked a complex and controversial case. His girlfriend, Karen Reed, now stands trial for second-degree murder, accused of backing into him with her SUV after a night of drinking. Prosecutors allege she left him to die in the cold. But Karen Reed's defense claims John O'Keefe was beaten inside the home and placed outside in a cover-up to protect powerful individuals. At the center of this public firestorm is Aidan Kearney, known as Turtle Boy, a blogger and YouTuber who has aggressively championed for Reed's innocence. Through live streams, articles, and viral social media posts, Turtle Boy has mobilized a movement fueling the Free Karen Reed campaign and pressuring authorities with claims of corruption and misconduct. His reporting has sparked debate, drawn legal challenges, and shaped public opinion, which is firmly behind Karen Reed. There's no doubt that public sentiment is behind Karen Reed. It's like 80 or 90% on social media, people who are voicing their opinions. And that's the reality. And you know, you want to debate why that is. Well, I think a big part of it is the publicity that has been drawn to this case by one person, Turtle Boy, Aidan Kearney, who's a local YouTuber, blogger up in Massachusetts, but now has a very national audience watching him talk about this case. And it's had a huge impact because it really started that whole movement. And there's a little more behind the story here that has been uncovered in court, or allegations as well that have been made in court. But I want to give you an idea and a look at some of the work that Aidan Kearney, known as Turtle Boy, he was on this show as well. And you know, it's been the single most important factor in creating and shining a light on this story and on this case. Let's take a look.
I've said from the beginning that I do not want this to go to trial. Like, this is not my last trip to Canton. I will be back.
How stupid do they think we are? How stupid? They're lying to us. But State Trooper Michael Proctor has abused our trust.
You're saying as you sit here today, you have no awareness in the history of this case that you were being threatened by an online blogger.
I was not threatened by an online blogger.
So I messaged Lucky. I introduced myself, and he said he didn't want to talk. So,
did you threaten him?
Absolutely not.
And he was there nearly from the beginning of all of this, way before the trial started, way before. And he's been facing charges for allegations of witness intimidation for some of the things that he's done. He says he's exercising his First Amendment rights. There'll be a case, a trial about that coming up. But what this has done, it's given an ability to completely change the public perception of this case from, you know, a woman is drinking a lot and runs over her boyfriend to, oh, is there a conspiracy here? Was this woman wrongfully accused and was she afraid? Completely changed the public discussion and public sentiment in the case, and has also allowed Karen Reed to raise money for her defense in all of this. And that brings us to the first question, or the next question in our investigation. Will this case provide a blueprint for future high-profile defendants? There have also been allegations in court that there was some level of coordination. At a minimum, there was communication between Turtle Boy and Karen Reed and or members of the defense team. And people who cover stories like me, we have sources, and we want to speak to those sources. That in and of itself, there's nothing illegal about someone covering a story and getting information from a source. But in this case, as a result of some of that information, we now have what we have here, which is a case which is way different. Is this the blueprint? Here to help answer this question, retired criminal defense attorney, knows a lot about high-profile cases. Kirk Nurmi is with us, and trial attorney Mike Jafer. Great to have you both here, because this is a big picture question. And I want to get your initial reactions, not your full answers, but your initial reactions. Do you think there are elements of this case that have created a blueprint in the world that we're in right now for future high-profile defendants? What do you think, Kirk?
I don't think so, because here we have a theory of a conspiracy that's backed by fact. We don't just have a conspiracy theory. And the fact that there's some support for what Mr. Kearney has been doing, what he's been saying, that helps people get in touch with it, and that makes it different other than just having a belief that a particular person is innocent that has no foundation in fact.
What are your initial thoughts here, Mike? Do you think there are any elements of everything that has happened here? The interaction with someone who has a high profile and a now loud voice on social media, you know, advocating and day after day, week after week, show after show. If you look at the number of shows he's done on this, I think it's close to 1,000.
Yeah, I fully disagree with my co-panelists on this. I think this is going to be a blueprint going forward. I think everything that happens outside of that courtroom osmoses its way into the courtroom, no matter what the jury sequestration potential is or the situation is, right? As of now, Vinnie, I'm no longer going to regard the O.J. Simpson case as a blueprint for high-profile trials. I'm gonna look at that title now belongs to Karen Reed's trial number 2, right? Because of what we just saw. Now, you know, this isn't just a moment, it's a milestone, right? Every future high-profile case is going to have to contend with this because this is a case that bled into the public arena in ways that we've never seen, and I don't think our jurisprudence system is ready for or can contend with it. So I don't know what's going to happen, but I know that everything is going to be different.
Now, another part of what the defense has done here, it goes beyond just Turtle Boy, but Karen Reed herself sitting down for interviews before a verdict ever happened here. Let's take a look at some of the clips which ended up being used against her inside the courtroom. Okay. She did a whole bunch of interviews. We know about that. Something else that has happened as a result of all this that I want to show you is the fundraising. Take a look at this. Justice for Karen Read Legal Defense Fund. A total of, and this is as of our last check after the defense rested, over $1 million. Over $1 million. And that's a result of everything that was happening on social media. I don't know if she got paid for the documentary or not, but she could have licensed certain things to the documentary people. That's very common. Let's take a listen to Karen Read.
The final count of my alcohol intakes, probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest vodka tonic. I mean, I'm not as clear as I would be if I hadn't been drinking. I mean, I had drank, so, and that led me to question, like, could I have hit him? Did I run over his foot or hit him in the knee? Did I incapacitate him? So when John got out of the car at Brian Albert's house, he took my full vodka soda, which is sitting in the cup holder.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in his drunkenness and in the cold didn't come to again?
Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? He asked, why was I saying, could I hit him? Did I hit him? He's in the general vicinity of where I last saw him. No one's coming out of the house. Jen's telling me nobody's seen him. So I'm thinking, Jesus, was I starting to pull away and I ran over his foot? Totally more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
All right, let me ask you, Kirk, is this a potential blueprint for raising funds for a defense to even the playing field with the almighty government?
Well, maybe, but we talk about, when we talk about, I haven't heard anybody say that this is a good idea in terms of the trial. And then money for a good defense isn't going to mean much if you sabotage it by going on TV and doing these various interviews. Vinny, I remember Miss Aries did these interviews. Before she was my client, she did these interviews. And these might have been sanctioned by her attorney, I don't know. But I know how powerful they can be as far as evidence against a high-profile defendant. So it's never a good idea. The money's not going to be worth it in the end, ultimately, if you're behind bars. That $1 million ain't going anywhere.
Mike Jafer, what are your thoughts? Because we've seen there's another high-profile case that's bubbling. Someone else who's raising 7 figures, Luigi Mangione. What are your thoughts about the blueprint here in garnering the social media support and using it as a means to fund the defense?
I co-sign what Kirk just said, because at the end of the day, I teach young lawyers at my office, you hold your breath every time your client opens their mouth, even if it's not in public. In this case, one day when the story about this case is written, the biggest curiosity to me is why she did those interviews. I would bet you my bottom dollar that her attorneys begged her not to do it. They probably even had her sign a waiver of liability because of how big of a piece of malpractice it would be to tell your client to go on a public speaking tour. I think I know why she did it. This is just a hunch. But, last September, she did an interview where she said that the people who are protesting in her favor are akin to Vietnam War protesters. When she said that, I thought to myself, I think she wants to go out there and tell her story because she didn't testify, which was a grave mistake. So in terms of a blueprint, yes, this is a blueprint to raise money, but it's a blueprint to raise money for your attorneys and get convicted.
All right, Kirk Nurmi, Mike Jafer staying with us. Still to come, what will happen if Karen Read is found guilty? Brutal murders of 4 University of Idaho students.
Oh my God, this doesn't happen here.
Detectives arrested 28-year-old Brian Kohlberger.
You could tell there was some off about him. He was stalking them. He was hunting them.
Forget about motive. We don't even have a connection.
This trial will be on Court TV.
And I pray that we have justice.
The Idaho College Student Murders Trial. Live coverage begins this August, only on Court TV.
The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone.
Because of the reasons we've been speaking, at least 80% of the people watching this trial don't agree with Hank Brennan, the special prosecutor, about what happened. They believe Karen Reed is not guilty. They believe the case hasn't been proven, and an overwhelming majority of them also believe that she's actually factually innocent. Not that it just wasn't proven, but that she's actually wrongfully accused of this crime. Let's take a look and remind you that there are supporters, not just online, but you also have supporters who show up at court. You have supporters online. They are everywhere.
Karen Reed was framed, and the world knows it. We have been subjected to domestic terrorism. We will not be terrorized anymore. Free Karen Reed! Love you, Free Karen Reed!
She's been framed.
She has to be exonerated. This is insane. I'm excited to see her have her day.
Now, because of limitations placed on the public by the judge, I mean, the scene has not been the same outside the courthouse this time around. But those people are still there, and the overwhelming support online has only grown, which brings us to the next question in our investigation. What will happen if Karen Reed is found guilty? And there's a couple different levels to this question. Let's bring back in our guests still with us. Kirk Nurmi, Mike Jafer. Let's start first with the people, the public. What do you expect, Mike? The reaction of the public, courthouse, online, if Karen Reed is found guilty here?
I think there will be big backlash. I think that she will become a folk hero more so than she is right now. I think that the same people protesting in her favor will be protesting outside of the appeals courthouse. They'll follow her all the way to the last day of her prison sentence if she's convicted. I think she'll just become just the Joan of Arc of that locality, right? So I think there'll be backlash. I also think that the government knew that this would happen, and they knew there'd be backlash, and they wanted no parts of a Karen Reed conviction, which is why I think they brought in Hank Brennan, an outsider. He's not a prosecutor. He's a criminal defense attorney. And not just any criminal defense attorney. He's the guy that wasn't one of the people representing Whitey Bulger and exposed actual corruption. And so I think the government said, look, if she's convicted, this is going to be big. And so they brought him in. So I think the backlash will be massive, Vinny, but it's a no-win situation. Even if she's acquitted, you're going to get the same backlash. It's going to confirm what the protesters are thinking. That's even if she's acquitted. But if she's convicted, I think you're looking at a many-decade, support, mob supporting Karen Reed. So I think it's a no-win situation.
Kirk, I want to show you something. This is from a poll that I did on my YouTube page, Vinnie Politan with the number 1. I asked this question. What do you think of Karen Reed? What's your opinion? Do you think she's guilty of striking John O'Keefe with her car? 14%. Not guilty because prosecutors did not prove their case, 21%. Factually innocent and wrongfully accused, 64%. What will happen if Karen Read is found guilty? Kirk, will people lose faith in the system of justice?
It could be. I mean, I think when you have numbers like that, people are obviously buying into the idea that either she was framed or something else nefarious is going on. And you see the amount of people protesting. I think, touching on what Michael's is saying, once we know that there's a verdict, we're going to see whatever barricade there is reinforced. I mean, I still remember verdict day in areas, Vinnie, the crowds and the chanting and everything else, with obviously opposite poll numbers. But you're going to have a lot of passion going on, a lot of media presence. You're going to have a circus outside there. And one of the things that's going to be is maintaining the safety and the order of the situation, because there's so much passion, getting people in and out of the courthouse. We've seen various court actors attacked for their role in this case. So, you know, that is going to be the number one consideration. And ultimately, unfortunately, if Karen Read's convicted, I think the court is going to be dealing with the real possibility that they're taking her into custody. And that is just going to ignite passions all the more, if it's anything but the DUI charge.
Mike, so let's talk about the appellate process, right? There's always an appeal, rarely successful, but sometimes they are. I mean, we've seen some high-profile ones come back here. Appellate judges aren't like anointed by God, they're human beings. Do you think they all kind of take a look at, well, if we overturn this conviction, that's gonna get ugly? Do you think that goes into their equation? And do you think that increases or decreases her opportunity to have a successful appeal if she's convicted?
To answer your question, 1,000% yes, it does factor in, because these appellate judges, believe it or not, are actually elected. They run for office and they have constituents. I'm not saying that they're just going to do what their constituents want, but it is absolutely going to weigh in her favor, because this case is different. Vinnie, yesterday I was talking to an accountant in Boston having nothing to do with this case, and I asked her, do you think she was framed? She said, absolutely she was framed. I live in Canton. I know the Alberts. You don't know. It's just different here, Mike. We all believe she was framed, which co-signs what you said earlier, which is public sentiment is in her favor. So I do think that the appellate judges would have just as much pressure on them as Beverly Cannoni and the jurors in this case. I can't imagine the pressure on them and their family members. This is different. This is a public spectacle, the likes of which we have never seen.
Kirk, we only have like 10 seconds left here, though, but what is it like for the attorneys in a case like this if Karen Read is convicted?
Well, you know, it depends on how they really feel about it, right? I mean, if you believe your client's guilty, okay, you move on with the day. But if you're really invested in it and you're on this big public stage, that can be a pretty big blow to those attorneys. But, you know, if they really believe in it, they'll fight with vigor at the appellate level as well.
Kirk Nurmi, Mike Jafer, great to have your insight. Thank you so much. I've said it from the beginning, this case is different. The way it was charged, the way the defense approached the case, and of course, the public reaction. Now, regardless of the outcome, I do believe you will see more cases like this in the future. It's the merger of social media, true crime, and high-profile cases. It's a way for defendants to raise money and change public perception. But it's also, but here's the big question. Is it a way to win a trial? That's a question for the jury. I'm Vinnie Politan. We'll keep digging for answers as the investigation continues.